Thank you all for taking the time today. I know it's a busy, busy time for most of us folks in the nonprofit sector right now, but thank you so much for taking the time to join and learn from us today. So we were quite pleased. All the tickets for today's sessions were claimed, and so we will be recording the session, as I'm sure you folks have noticed, but not the Q&A. So we do hope that you stick around until the end to hear our great guest speakers answer some of the top questions that were submitted through registration. And I would like to acknowledge that Integral Org is based out of Mohkinstsis, which is the Blackfoot name for elbow. This refers to the confluence of Elbow and Bow rivers that run through Treaty 7 territory. Mohkinstsis is the traditional territory of the Blackfoot Confederacy, which includes the Siksika, the Piikani, the Kainai, as well as the Stoney Nakoda First Nations, consisting of the Chiniki, Bearspaw, and Good Stoney First Nations, and the Tsuut'ina First Nation, and finally the Métis Nation of Alberta, Region 3. At Integral Org, our team recognizes that there exists a tension between the legal governance structures that we work within, as well as our efforts towards truth and reconciliation. And so we do accept our responsibility to work towards reconciling this tension. And we all, settlers and Indigenous included, have a connection and responsibility to the lands that host our lives, our communities, and our work. So for folks that might be new to us, a bit about ourselves. Integral Org is a capacity builder and a nonprofit ourselves, and our goal is to equip you with the knowledge and support so that you can best do the work that you do. We work in many core areas, of course, nonprofit legal education being one, but with our expertise in board development, strategic planning, and now nonprofit leadership, just to name a few. We do like to work with organizations at any point in their life cycle with an approach that integrates the many aspects of a thriving nonprofit. So today you'll all be in the very capable hands of Yvonne Chenier, today's moderator. She is a lawyer and a philanthropy consultant and a co-founder of Integral Org. Yvonne brings more than 35 years of experience helping those in philanthropic, nonprofit, and social enterprise sectors, as well as the general legal counsel and as an advisor on planning, organizational, regulatory, and governance matters. So I will just spotlight her right now so that everyone can see, and you can take it away, Yvonne.
Thank you, Liz, and welcome everyone. And in my many years of dealing with nonprofit organizations and charities in Alberta, I know that many of you are overwhelmed with questions about the protection of privacy laws or even best practices. So the purpose of today's session is to help you with some of those questions that you've had and you still have today, even after a few other sessions that we've done or others have done on privacy laws for nonprofits. So where do we start? Where do we start in today's session? We're starting with Alberta law. We're starting with the Personal Information Protection Act in Alberta. That's what we're going to be talking about today. There may be other legislation that applies to you that also deals with privacy laws, such as the legislation your organization is incorporated under. Has a lot to do with the privacy laws that may apply to you. I use the section 36 and 36.1 of the Societies Act, which I know most of you are familiar with and many of you are incorporated under, and that specifically speaks to privacy as you collect your membership information and the use of your member list. And then depending on what your organization actually does in Alberta, other laws may be applicable. If you're a healthcare kind of charity, then there's privacy laws applicable to healthcare that might apply to you. And many of us in the nonprofit sector, we have contracts that we enter into. We have funding agreements that we enter into. And many of these specific contracts require us to collect or use personal information in a certain way, i.e. for funders' use or statistics or something like that, our own internal use. And of course, some of you may cross borders in your operations, and depending on the jurisdiction of where your activities and your operations are actually taking place, those countries or indeed that province's laws may apply to your specific activities in that jurisdiction. And hopefully, and maybe your organization already has policies and procedures in place for privacy and how you deal with personal information. And those, of course, are very important to your specific organization. So these are lots of things to consider. But what we hope you will take away from today is a basic understanding on how to comply with the Alberta's PIPA as it applies to your specific organization and your activities in the province of Alberta. We hope that after today, you'll review what personal information your organization collects and why, and what it does with it. And biggest takeaway would be to learn about some of the best practices, regardless of the laws, but some of the best practices for your organization as it collects and uses personal information. So consider taking basic steps today to protect personal information and maintain the confidence of your employees, your funders, your donors, and your volunteers, and give your board the confidence that its duty of care to your organization is being fulfilled. So today we have wonderful speakers. We're very fortunate that we have information and privacy managers with us today to give you the rundown on Alberta's PIPA. I will introduce them, and then we will have a poll first, and then I will introduce them and turn the presentation over to them. So we need to know a little bit about what you know about PIPA first. So Liz, run the poll.
So it seems like most folks are at the sort of 3 or 1 out of 5. And I'm trying to see, we're seeing a lot of reasons that people collect personal information, a lot of email lists or membership lists. We have donor information, grant information, childcare program, being able to contact parents. So thank you.
Good. That poll is very revealing, and it does say that there's not too many people in the room who know a lot about PIPA, so that's good, because our two guest speakers certainly do. So first we have Marie Pacharel, and she's been working with the Office of the Information and Privacy Commissioner of Alberta as a Senior Information and Privacy Manager since November 2018. She works in the informal case resolution team, mediating and investigating complaints and requests for review under Alberta's privacy legislation governing the public, private, and health sectors. Prior to OIPC, Marie worked as an investigator with the Alberta Ombudsman's Office. Marie has an LLB from Dalhousie University and a postgraduate certificate in public administration from the London Metropolitan University. Tara Pervasep is a Senior Information and Privacy Manager with the Office of the Information and Privacy Commissioner of Alberta. And Tara's focus is on investigating complaints and requests for review to the Commissioner's Office. Tara has specialized in the application of PIPA since its inception way back in January 2004. So the past 20 years, she's been working with the Office of the Privacy Commissioner. She's been an independent privacy consultant doing privacy gap assessments and writing records retention schedules for organizations with an aim of assisting organizations with best practices and privacy compliance. So we have the best information here with us today. So let us hear what they have to say. I'll be moderating the questions, and we will have a Q&A session after, as you've indicated. And we also have a lot of questions we were submitted beforehand, so we'll try to get to most of them too. Thank you.
I hope everybody can see it.
Yep, that looks great.
Good. So thank you to Integral.org for inviting us. We always like the idea of taking advantage of the ability to go out and talk to people about the work we do and providing kind of further information with regards to the various privacy legislation in Alberta. So first of all, I just want to say that this presentation is not intended as, nor is a substitute for legal advice, and is not binding on the Information and Privacy Commissioner of Alberta. We always have to start with that. And as well, oops, now I got to go there. Okay, and as well as a little bit more responsibility for compliance with the law and any applicable professional or trade standards or requirements remains with each organization, custodian, or public body. All examples are used as provided as illustrations. The official versions of the Freedom of Information and Protection of Privacy Act Health Information Act and the Personal Information Protection Act and their associated regulations should be consulted for the exact wording and for all purposes of interpreting and applying legislation. The acts are available on the website, Alberta's King's Printer, and any further reproduction or use of this presentation requires written permission from the Office of the Information and Privacy Commissioner. So that's just our standard disclaimer. So what we're going to cover today, we want to talk about who we are, and not just the presenters, but also as an office and what we do. Give you an overview of PIPA, and then talk about as PIPA applies to nonprofits, and then go into maybe some best practices and talking about resources and answering questions. And we're all going to try to do that in 45 minutes. So we'll see how successful we can be. So our office, I'm going to be very basic on this. Our commissioner is Diane McLeod. We basically have three main areas: mediation and informal case resolution, investigation and compliance, and our adjudication. That's just basically our three areas. We have some other elements, but that's kind of things. Both Tara and I work in the informal and case resolutions aspects. And investigation and compliance tends to deal more with kind of special investigations or with where people are trying to do things like doing breach reports, that kind of stuff. Adjudication is usually what happens is if complaints and requests for reviews come to us and we can't resolve them, they go up next to you can request an inquiry, and it's up to the commissioner to decide whether or not inquiry occurs. And if it does, it happens at the adjudication level. And turn it over to Tara for the next.
Thanks, Marie. And I just want to say thanks to everybody who participated in that poll at the beginning. That's actually really helpful for Marie and I to see kind of everybody's balanced understanding about PIPA. But I think a lot of the times when people think about privacy, they think about breaches. It's a sexy headline, and it's almost something that's kind of become white noise. I'm sure there's many people who have received a breach notification. Did your email get disclosed to someone else? Were you somebody who perhaps had something mailed to you incorrectly? It's a very common thing, and lots of threats to privacy. But of course, when we're talking about PIPA and we're talking about privacy, it's way more than every headline that you see. Can go next, Marie. PIPA, we're talking about today, that applies to nonprofits with specific elements, and we'll chat about that. But there's also the Freedom of Information and Protection of Privacy Act, or FOIP, which is public sector legislation. So government bodies, schools, educational institutions at the post-secondary level, they're all covered by FOIP. There's also the Health Information Act, which governs all health information, so mine and yours, everybody in your family, your kids. So we, in our office, as Marie said, we do work on FOIP, HIA, and PIPA. And of course, as nonprofit organizations, PIPA will apply to you in some circumstances. Not all, but some. Quick look at PIPA at a glance and what the elements of PIPA are. It's really, I like to think of PIPA as a balancing act. The word reasonable appears in this legislation, I think, 64 times. What a reasonable person would consider reasonable in the circumstances. So it's really about the right of an individual to have his or her personal information protected, but also balanced with the needs of organizations to collect, use, or disclose. It's not all about protecting personal information or all about the rights of an organization. It really is a balance between the two. And it provides what we call common sense rules or reasonableness rules for the collection, use, and disclosure of personal information by private sector organizations. It also provides, and we'll chat about this, which is really important for people, a right of access to your own personal information and the ability to have errors within your personal information corrected. So PIPA applies to nonprofit organizations. Specifically, if you want to read this, which is very exciting for Marie and I, but not always everybody else, it's under Section 56 of the Act. So nonprofit organizations are defined as, are you incorporated, or is your nonprofit incorporated under the Societies Act? Is it incorporated under the Agricultural Societies Act, or is it registered under Part 9 of the Companies Act? Your incorporation certificate, depending on type of organization you are will tell you each of these things. Marie and I can tell you for sure that we rarely see number 2. We're very commonly seeing number 1 and number 3. And PIPA applies to nonprofit organizations when they collect, use, or disclose personal information, specifically in connection with a commercial activity. That's really, really important. If we are not operating within a commercial activity, and we'll define exactly what that is and how that works and give some examples, then PIPA may not necessarily apply to you. But if you are doing things with commercial activity, we comply with PIPA for all of those activities. Now, one of the disclaimers that we always say in our office is, even though PIPA may not apply and you may not be engaging in a commercial activity, it's still never a bad thing to understand and, I don't want to say live by the elements of PIPA, but incorporate those things, because legislation is changing. They're doing a review of PIPA right now, and I know that they are looking at the application of PIPA to nonprofit organizations, so that commercial activity could change sometime in the future. So it's really all about personal information. If there's one thing you take away from this, is what is personal information? And it's defined as information about an identifiable individual. It's not just something that relates to someone, it has to be about you. So what are some of those things? Your demographics, of course, your name, your birth date, your address, any ID numbers, your social insurance numbers, those would all be things about you. Your physical description, financial information, those are all things about you. Personal information is not confidential information. Those are different things. So let's say we had 3 organizations. We have an architectural firm, we have a woodworking company, and we have a grocery store. Personal information across all of those things would be the same, but confidential information might be different. So at the woodworking company, it might be drawings. At the grocery store, it might be where we place certain items on the shelf, and somewhere else it might be something different. But the personal information or people, information relating to people across all of those industries would be the same. That maintains the same. And it's really focused on consent. Do we have consent to collect, use, and disclose personal information? It's a consent-based legislation. So what are the primary principles of PIPA? Number 1, let's designate a privacy contact. If someone comes to your organization and has a question about privacy or about how their information is used, who do they talk to? Have we designated someone that can answer those questions? The second is, do we or have we developed policies and procedures for compliance? Are there guidelines or things in place that talk about how we collect, use, disclose, and safeguard personal information? We are only to collect personal information under PIPA for a reasonable purpose. There's that word reasonable again, which keeps showing up over and over. And we only collect the information that's needed. So what are we collecting? Why are we collecting it? Is it reasonable? Are we only collecting the bare minimum that we need under the Act? And are we collecting it directly from an individual? Now, there's some pieces of the Act that allows us to collect information from other people, but typically we would get consent and collect it directly from the individual. And are we telling people why information is being collected and how it's going to be used and disclosed? That is also a really important element of PIPA. A practical example of this is, let's say you go into, a building, an apartment building, and sometimes they'll have a sign on the door that says video surveillance is being used. So it's notifying people and telling people that their information is being collected. Are we obtaining consent? There are elements of PIPA that allow us to collect information about people without getting consent. So one easy example of that is, are we going to collect information about somebody in the case of an emergency? We're not necessarily going to go and ask Bob if we can collect his information if it's an emergency. We might just need to outside of the Act. Sometimes for the purposes of litigation or an investigation, which are very narrowly defined in the Act, we can collect information without consent. We are using and disclosing personal information only for purposes for which it was collected. So very easy example. If we're collecting your birth date for the purpose of, hiring you, and we require that information, we may not want to send you a happy birthday note because we didn't collect your personal information or your date of birth for the purpose of wishing you a happy birthday. Nice thing to do, but yes, I've actually had someone complain about that. We need to make sure that we ensure personal information is accurate for the purpose for which it's going to be used. Accuracy is really important under PIPA as well. Reasonable safeguards. We get a ton of questions about reasonable safeguards, and they must be in place to protect personal information from risks of unauthorized access, use, and disclosure. And the safeguards don't have to be perfect. There's no requirement. We can never make everything perfect, but are there reasonable safeguards in place to protect personal information? That's a requirement under the Act as well. So keep information only as long as it's reasonably necessary, and make sure that you destroy it or delete it when you don't need it anymore. The more information you have, the greater the chance that you could have the information subject to a breach, which we definitely don't want. And on request, individuals have the ability to request access to their personal information from an organization. So I just want to really quickly stop here for a minute and talk about what access means. So if someone comes to you and says, I am requesting access to my employment file, for example, we get a lot of requests for that. And someone says back to them, well, yeah, you know, we have it, but it's private and you can't have it. When we request access to information under PIPA, the organization takes in that request. They look at it and they say, okay, so Bill's requested access to his employment file. And we have to process that request for access. And what that means is we have to search for all of the information that Bob has asked for. So we'll go and we'll get his employment file. We might ask human resources or finance or other individuals within the organization that might have information related to this employment file. Then we have to go through, after we collect all of the information, we have to go through it and process it. What can we give to Bob that's responsive to his request for access? What is his personal information? Perhaps there might be things in there, let's say there was a termination, and we might not want to give Bob everything. We have the ability to sever some information under the Act, and we might not give him all of the information. There might be some that's severed. When we respond to Bob, we tell him, this is what you're getting. Maybe we've redacted and severed some information. This is what you're not getting and why. And then we provide him with that response. So sometimes it's not always clear that somebody's asking for or requesting access under PIPA, but they do have the ability to do so. So I don't know if anybody, and perhaps we might have a question about this at the end, if anybody's received a request for access, but happy to chat about that more if there's any questions moving forward. Privacy breaches. There is a requirement under PIPA for organizations, if they have experienced a breach where there is a real risk of significant harm to an affected individual, they have to notify the Privacy Commissioner's office, and we conduct a breach investigation. It's a mandatory requirement, and breaches can be both internal and external to an organization. So often we think of breaches as someone has broken in and gotten access to information, or there could be ransomware or something like that. But breaches are also internal. So if I work in, if I work in outside of HR, but I find that I have access to an HR spreadsheet that lists everybody's name, address, salary, data hire, that could be an internal breach. So we need to look at, organizations need to look at, is there a real risk of significant harm to affected individuals? And if there is, there's a requirement to notify our office, and the commissioner will let the organization know if they're required to notify all of the affected individuals. So at the very beginning, when we talked about threats to privacy and breaches, if you've ever received a notification, that's probably because it was a requirement under some legislation that an organization had to notify the affected individuals of the breach itself.
And it's my turn. So I'm going to be talking about commercial activity. As we talked about, as we noticed earlier, we said that if you are, so even if you're considered a nonprofit under the 56(1)(b) of PIPA, you can still be. There are still elements of what you do that can still be captured under PIPA. One of the things is commercial activity, and commercial activity is, so there are very specific elements, and selling, bartering, or leasing membership, donor, or other fundraising lists. If you do that, that part of what you do is subject to PIPA. Operating a private school or an early childhood services program, as defined in the Education Act, that part of what you do is under PIPA. operating a private post-secondary institution, which, as Tara and I were speaking about, I've never really seen that come through our office, but hey, that part of what you do is subject to PIPA. And then the catch-all, any activity that is of a commercial character, which is a lovely thing because commercial character is not defined. So no clear, precise definition. So what we're left to do is try to figure out what that is. So if you take a look, our orders have interpreted this term, and what we've I'm setting out some basic principles based on how our orders have approached and addressed this issue. First of all, we take a very broad approach to the interpretation of what is a commercial activity, commercial character. And the reason why is that the legislation used the specific terminology of commercial activity, or commercial character. And the idea is that if they were only going to look at commercial activity, they would have said so. So by using the terminology commercial character, they're wanting a broader interpretation of this. So what that means basically is we're not necessarily looking at whether or not it fits a very narrow thing. We're looking at it broadly and say, well, can it be considered commercial? Does it have commercial character? Can it be considered a commercial activity? We're not looking at the commercial activity, but the commercial character. Whether or not money's exchange is not enough to establish commercial character or activity. So even if there's no exchange of money, it still can be characterized as commercial activity. Collecting, using, or disclosing of personal information is not enough to capture that. There has to be other elements. Just one transaction can be enough. And having paid employees is not considered a commercial activity. So as I was looking at an order, basically it says nonprofit organizations are not in the business of having paid employees. So that is not a commercial activity. It really is. It's less about those elements and more about what you do in the activity. Yeah, I love this quote, and all of us will use it. If this is an order, it says, if it looks like a commercial activity and it walks like a commercial activity, then it is a commercial activity. And we can say, well, that's a rather circular argument, but it is in essence what we are looking at is, does the activity involve buying, selling, or exchange of goods and services? Does the activity have a trade-like or business-like nature? And are the activities being carried out as if they are a business? It's not whether or not you want it to be a business. It's not whether or not you are looking to make a profit. Those things aren't the elements. It's, are they being carried out like it's a business? Or is there, can you look into the kind of business world and say, oh, look, they can do these things. It's considered a commercial activity there. It should be considered a commercial activity in the nonprofit sector. So we're going to go into real world examples. So I'm going to cover basically kind of 4 elements. I'm going to look at personal information, personal employee information, nonprofit, and the commercial activity stuff. So I'm going to try to bring in how our orders have looked at these issues and give you examples from those orders. And I'm going to try to do that in 10 minutes. So personal information, it's probably one of the things that we it's not that we struggle with it because it can be it's very dependent, context oriented, but it is something that actually, because it's what we call a jurisdictional issue. If the information before us is not personal information, then we don't have a jurisdiction to look into it or to make findings or to make recommendations around it. So it's actually one of the first things we look at to try to make a determination, because it impacts whether or not we actually have the authority to look at a complaint or a request for review. So some of the basic issues. So I've kind of listed some orders. If you want, you can go and look at them. I'll try to actually just deal with them quickly, but these orders can be found on our website. And as Tara said, the term about is much narrower than related to. First thing, it has to be an identifiable individual. So for example, if you have something that is like, if you have security cameras that takes videos of people walking by, and it's so grainy and so, and the things, that may not necessarily be about, if you can't identify the individual in the information, in the record, then it's not personal information. So the first thing I want to talk about is, okay, it includes what someone said. It can include what someone said, expressing an opinion, so it's their opinion. The fact someone has done something or taken certain steps, the personal history, personal details, all of that is considered about that person. So it's captured under terminology of personal information. It excludes the related to. So for example, strategies and advice provided to parties. So one of the things we often look at is people want, as Tara said, people want their personnel file, and it has, so information like name, address, all that kind of stuff is about is their personal information. If there's information about it, so if somebody makes a complaint about you, that complaint is actually, because it's about you, is technically kind of your personal information, but how a public, how the organization deals with that is not your personal information, because it's related to the actual complaint. Information generated or collected in regards to a complaint is not necessarily about that person. Information relating to a person's work or produced by a person in the course of their work is not personal information unless it has a personal dimension. For example, if I sit up and I write an email from work to another work person, that's not my personal information, because I'm doing it in the course and in the element of my work duties. If in that email I say, I'm sending an email to Tara and I say, oh, by the way, I had a great weekend, I did blah, 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 that information, even though it's contained in my work product, is actually my personal information because it has a personal dimension to it. So those are some of the things to kind of think about. A couple of examples. So we're looking at P2023-03. It's a case involving Advanced Upstream Limited. The complainant was a former employee, and it alleged the organization disclosed his personal information when it sent a complete copy of his employment contract to another corporation. So he'd left, and they sent a whole bunch of information to another corporation. The info included contractual terms under which the complainant worked for the organization, set out his employment agreement and confidentiality and intellectual property agreement, and some other information. So what our order found was that the name, the fact he was employed by the organization in a particular position, the fact he was believed to have commenced working for or with the competitor, all was considered personal information because it was about him. His address, his salary, his benefits, his severance compensation, all of that is his personal information. The non-disclosure, non-competition, and non-solicitation clauses themselves were not his PI, but because they were connected with his name in this thing, that's the personal dimension that comes in, because it would tell somebody about the certain restrictions on his job. So that's his personal information. Information describing the duties and responsibility of the complainant's position within the organization was not considered his PI. Another case, 2020-04. It's involving a law firm. We often use this one for because it actually has a really good discussion around PI. And this case, two people who were involved in litigation with somebody that law firm was representing. They submitted an access request for their personal information, and then there's this actual section paragraph that basically said personal information in the records includes only information about them, such as, and I've just talked about it, but things like what they would have done with regards to dealing with their complaint or their litigation is not their personal information. So because it's related to them, not their personal information. Highline Farm Equipment 2020-07. This was a complaint from a former employee that the company collected, used, and disclosed his personal information when it accessed text and emails made on his work-issued iPhone. And again, so the public, so our order found that the majority of the information that was on that was at issue here, that was on the iPhone, was not his personal information, because it was personal information related to his work. However, there were some things that were considered his PI, like texts he sent with regards to a family event, his opinions about certain members of his family and things that are happening. Those opinions, those things were elements, were his personal information. Another one, 2016-02. This was a condominium that had a surveillance system set up. That order found that surveillance cameras capture the personal information of individuals indiscriminately. A surveillance camera does not capture only information about persons who break the law, but it captures the images of those who get captured by that thing. So that's an element that says video recordings are people's can include people's personal information. Okay, so next one we're going to go into is personal employee information. Now, personal employee information, the reason why even though a personal employee information is a subset of personal information, but the reason why we create a distinction is because there's actually different things you can do with personal employee information. That there's certain different rules and things that deal with that. And basically, and determining what is personal information, personal employee information is context dependent. For personal information to apply, it has to be collected, used, or disclosed solely for the purpose of establishing, managing, or terminating the employment relationship, or post-employment or post-volunteer work. Now, here's an so some orders around that. The big one is, or the most recent one is Order 2021-02. It involves the Anglican Diocese of Calgary. Here, a complainant who was a reverend made a complaint that the organization had disclosed his personal information. What happened was he and others had been involved in a same-sex civil marriage ceremony. He had written to the bishop on that, and the bishop had responded to him around that. Information that was with regards to that interaction was then sent by the bishop to all these the various diocesan members. So it was that disclosure, that sending out to other churches and other bishops, other dioceses, that was considered the disclosure. So the adjudicator determined that the organization did not have the authority to use or disclose the complainant's personal information in the Archbishop's letter responding to the complainant's action. So even though there was some PI, but the stuff that was sent out wasn't being used or disclosed for the purpose of managing that relationship, that employee relationship. So it couldn't be it couldn't be considered personal employee information. Another one is private PricewaterhouseCoopers Order 2021-01. That dealt with information that was being collected by PricewaterhouseCoopers. That dealt with not only just the employee, but his spouse. They basically said, we need that information because we have certain requirements around financial independence and disclosure around those things that are regulatory based. And it was determined that that information, actually, because it was being used to manage that relationship and to manage it within the kind of the industry, was personal employee information. I'm going to skip through some of these things because we're running behind. We're going to talk about real world examples for nonprofit organizations. As we said, if it it has to come in under those segments, those sections, those acts cited in PIPA. If it doesn't, it will not be you can't claim nonprofit if you don't have that. A couple of really interesting orders around that. We'll go back to the Anglican Diocese of Calgary. They tried to make the argument, which refers to, and it was concluded that profit, because they weren't incorporated under those or didn't register or incorporate under those sections of those acts, they could not claim nonprofit. Alberta assessors, no, we won't go with that. Fairways, no, I won't go with that one either. Sorry. To Project Porchlight, 2013-03. This was a they tried to argue that they weren't subject to PIPA because it was incorporated in Ontario under legislative provisions equivalent to those found in the statutes listed in section 56(1)(b)(1). And the adjudicator found that they didn't have the latitude to recognize other jurisdictional legislation. It had to be under those legislations listed in the Act. Commercial activity. Okay, two main orders that we look at. First order is 2017-07, Castle Downs Bingo. Basically found that managing employee is not a commercial activity, but managing employees hired for a commercial activity is managing those employees in connection to that commercial activity. So like I say, it's about what the activity is and what the employee is dealing, what activity they're involved with. Employees can have both commercial and non-commercial duties. Therefore, nonprofits need to determine if an employee is hired is in relation to a commercial activity, then PIPA applies. If an employee is hired in relation to non-commercial activity, but their activities change or adding new duties, you need to determine whether or not that then might bring that employee into a commercial activity. Castle Downs Bingos is an interesting one. It is a nonprofit organization that operated a lounge. And this was the complaint was that the person who was the employee working in the lounge had some personal information that was looked at and disclosed. And they determined that the actual activity of selling alcohol was commercial, and as such, that person, and because that's what that person did, that's what PIPA applied, and they. So, and the other thing to remember from this order is that it's even in cases where employees perform relatively minor or occasional duties related to non-commercial activities, such as updating contact information on membership lists, that still doesn't mean that they are, excluded from PIPA. It's about what they primarily do, kind of thing. Another really important one is the Legal Aid Association of Alberta. P 2013-D-01, just because it deals with personal information and make decisions personally affecting individuals does not mean PIPA applies. So it's not about the act of what you're dealing with, it's about what you're doing. Determined that from an operational or service standpoint, nothing significantly distinguishes the Legal Aid Society from a private law firm, and so PIPA applies. And PIPA applied whether or not legal aid coverage is denied to a person. So in this case, it dealt with somebody who went in and was interviewed, did the whole application process to see if they could be covered by legal aid. They weren't, but they wanted the copy of the information that they provided. And what we determined was the very fact that even though whether or not they were accepted for legal aid, legal aid in and of itself acts like, and what they do would be considered a commercial activity outside of the nonprofit, outside of their world, into the private world. And so PIPA applied. Whether or not they were accepted as a client, PIPA still applied to that information. Anyway, so that's basically my little bit of my little walk through the happy world of PIPA and nonprofits.
All right, now that Marie has made it abundantly clear about everything of commercial character, you can probably tell that most of our work at the very beginning, we look at things and we often say, does this even apply? And it takes us sometimes quite a while to actually figure out, even amongst each other. And we do this all day, every day. But let's take a look at some of the overall best practices for PIPA. First thing, you got to know what you have. You really need to know what you have in terms of personal information. What do you collect about your members, your clients, your customers, your donors, your employees, your volunteers? It's almost like having, sometimes I speak with folks and they have an inventory of personal information so they can truly understand what it is they're collecting. And that can be an organization-wide group effort, because we might have people in different places collecting different things. And when we get this inventory, we're like, why do we have this? Do we really need that? Why do we have that? Do we really need that? It looks like we've got finance and HR and somebody who works in communications all collecting the same thing. Do we really need to be doing that? The second thing is, right to that point, you got to know why you have it. Why do you have it? What is the purpose for your collection? And then do you really need it? Again, back to having that privacy contact person, really, really important. I think it's section, is it 5 or 6, Marie, that requires that an individual be accountable for privacy, and we need to make sure that we have. You don't necessarily have to have a privacy policy in place, but there need to be guidelines. So we have folks that'll come to us and say, well, I went to XYZ organization and I asked them for their privacy policy, or I asked to speak to someone about privacy and they had no idea what I was even talking about. And they make a complaint to our office and then we investigate and find out, okay, you don't actually have anybody accountable for privacy. You don't have any policies or guidelines in place. You're in contravention of the act. The recommendation is to make sure that somebody's accountable for it, that you put their name out there and to develop some policies to make sure that they're in place at your organization. We need to make sure we have consent to collect personal information. Again, there are certain places under the Act where an organization has the authority to collect without consent, but those are very limited. And we have to give notice. Why are we collecting personal information? People need to understand. I'm collecting this information because X, Y, Z. Give them notice so that they understand and have the ability to withdraw their consent or to not participate if they don't want to. Best practices, again, safeguarding of personal information. Make sure there are reasonable safeguards in place. Now, I just want to mention this quickly before I forget, but at the very end, we have a slide that's got some resources of where folks can go to look for different things, but there is a safeguarding assessment, a self-assessment on our website. And again, go look for that in the other, one of the slides kind of near the end, but it's great because it has a ton of questions in it. You're not going to have the answer and it's not going to be perfect for every single question, but it's a great self-assessment and it goes through all different types of safeguards. If you're a massive organization, then you probably want to have as many of those as you can. If you've got 3 people, you're not going to need to have a yes or an answer to every single thing in there, but that safeguarding self-assessment is great. And it's also used not only for organizations, but also for public sector, public bodies under FOIP as well. We need to understand access to personal information requirements and how to process a request for access. So that's back to if somebody asks for access to their information, how do you actually process that and give them a response? Don't have to give them absolutely everything you have about them. There is the ability to redact under the Act as well, but make sure that you know how to recognize a request for access and how to respond as well. Don't keep personal information longer than necessary. Remember those breaches. Section 35 of the Act talks about the retention requirements under PIPA. I get asked this all the time. Well, how long do I need to keep this? Or how long do I need to keep that? Well, it's really, I think it says a year after you make a decision about somebody. However, I write records retention schedules for organizations, and it really depends on what other legislative or regulatory requirements are in place. There could be something under the Income Tax Act, or there could be something specific to your industry and your organization that will dictate how long you need to keep certain records. Be aware of those breach reporting requirements. So our website has a lot of information about how to manage a breach. What do you do if you discover it? What are the steps that you need to take in order to manage that? It's all about mitigation. Are we shutting it down? Are we figuring out what happened? Are we hiring somebody to help us with cybersecurity to understand the elements of the breach so that we can prevent it from happening again in the future? But also, if there is a real risk of significant harm to an affected individual, we need to report that breach to the commissioner, and also probably will end up notifying the affected individuals. The commissioner herself will tell people if they have to notify the affected individuals, but most of the time when people come to our office reporting, they provide notification to the affected people at the same time. And the Act defines exactly what it is that you need to include in that notification letter as well. So what is a privacy breach? It's the unauthorized collection, access, use, modification, disclosure of personal information, or it can be the loss of information. I know that we don't all carry around USB keys anymore, but lots of folks put in a USB key in their pocket and they go home, and the next thing you know, they don't have it. Or leaving their laptop in their car, going to Earl's for dinner, and they come out and their laptop's gone. But we would then need to know every single person that was on there and their personal information, because we have to notify them as well. So if we have a whole bunch of stuff on there that's 25 years old that we probably don't need, that's another reason to really look at those retention requirements as well. And what are some of the most common causes of breaches that we have? It could be system compromise, social engineering, that ransomware again, human error, a lot of misdirected emails and faxes. A lot of organizations will put an attachment in an email and then go to send it to somebody, and they've accidentally sent it to the wrong person. Easy thing to do there, make sure that you password protect any attachments with personal information in them, and then send the password separately. Because if you mean to send it to Bob Smith and you accidentally send it to Bob Schultz, if the right Bob doesn't have the attachment password, he can't open it. So it's not actually, there is no breach because nobody actually saw the information. Sometimes we've got theft. Sometimes we've got rogue employees that download information. So making sure that when people have left an organization, cut off their access. If you have the ability to do audit logging or monitoring of personal information and who has access to it, that's something, again, a lot of bigger organizations would be able to do that, but rogue employees could definitely be a problem as well. Are we disclosing to friends? Are we disclosing on social media? We see this very commonly, not necessarily under PIPA, definitely under the Health Information Act, but be careful for your employees what they're saying on social media or to their friends about clients, customers, employees, because that could be a breach as well. Here's this resources, a little bit about the annual report, where the PIPA website is. Privacy impact assessments can be done. They're not required under PIPA. They are required under the Health Information Act if there's a change to the way that we collect or use personal information. A little bit more about privacy breaches, what to do, how to manage them, how to file a complaint or a request for review to our office. Some of the decisions that Marie was talking about, those orders set the legal precedent in our office. So that's when she was talking about orders, that's what those mean. And then the safeguarding self-assessment. And I think I saw it pop up in the chat as well. And I think that's it. So we have a few minutes for questions, and certainly Marie and I are available to chat longer if we need to as well.
Well, thank you, Tara and Marie. That's a lot of information you just gave us. not only about what the law is in Alberta as it applies to nonprofits, but probably more importantly, where to find best practices and what they are. Because what I take away from reading anything about our privacy laws in Alberta is words like it only applies to personal information for identifiable people. It applies when you're doing commercial activities. Consent is important, and there are some exemptions for many organizations in our audience here that would be either societies or ag societies or Part 9 of the Companies Act. So in some of the questions, a lot of the questions we're getting and had received before the presentation dealt with donor information, member lists, etc. And again, it depends, really, it depends on a lot of things. For example, under the your incorporating legislation, if you are incorporated under the Societies Act, the Act specifically talks about that you have an obligation to collect personal information from your members, and then you have an obligation to make that membership list available to your members for society purposes. And it goes on to say if you have consent, then you have the ability to have that membership list used by members for other purposes. So consent in your intake is very important, but it depends what statutes you're incorporated under. If you're incorporated under the Canada Not-for-Profit Corporations Act, everything I just said doesn't apply to you. So that depends. And then the donor information, again, that's a very good question. What are you collecting the information for? And is it a commercial activity? Does it have a commercial character? So I think those are good questions for our speakers about collecting information like donor information when they give gifts to our organizations. Does that have a commercial character to it? Selling memberships itself to our organization, does that have a commercial character to it, or how would that be looked at?
I can take this. And of course, everything is case dependent, right? But if we are selling a membership, that to me would be something of a commercial character, for sure. Marie talked a little bit about it's not always about the exchange of money, but I would say that would be, if I were looking at jurisdiction, that would be of a commercial character. And I think there's a lot of people on here probably that might have that applicable to them as well. But I'll let Marie weigh in too.
Yeah, but also in its under 56(1)(b), it specifically says selling, bartering, or leasing membership, donor, or other fundraising list is a commercial activity. So, and probably, and if you don't feel it fits exactly under that, probably it would fit under a commercial character. I would probably say that even, I don't know how. I'd want to know what you mean by why you don't think that element of that section doesn't apply to whatever you're thinking or doing, because I'd be saying, well, if you're doing it for any, if it doesn't fit there, then it might probably fit under the commercial character aspect.
And in the end, best practices would reign. What do your members expect? What do your donors expect that you're dealing with their personal information?
Yeah.
And I think the thing to remember is that if you're collecting that information and with the purpose of sharing and with the purpose idea that other people are going to know about that information you're collecting, you have to let people know before they provide you that information that that's what's going to happen, because then that gives them the choice as to whether or not they wish to actually be part of that sharing. And I think that goes with the issue of informing, but also with regards to consent, because it's often the case that we might say you may not have necessarily overtly consented to the collection of your information for the purpose of selling, but if it's clearly said at the point of collection, this information will be used, blah, 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 then we'd be saying that by the fact that you kind of continued means that you've consented to that kind of thing. If you're doing something different than what you've actually said, I'd be saying you're going into the gray area where you may not necessarily have consent. Right, Tara?
Yeah.
Anyway, I think we need to wrap up now. I do thank you, and very informative, and we look forward to having you guys back potentially to talk about some of these more specific issues, and IntegralOrg is a resource to you as you need to interpret what the nonprofit sector needs in Alberta for sure. But I'll turn it over to Liz to wrap it up, and I thank you everybody for your participation today.
Yeah, thank you so much, Yvonne. Yeah, I'm just mentioning as before, the recording of this will be sent out. We have to take out the Q&A section though, and then we will pass along what resources that we can so that it's accessible to you later. And yeah, I'd just like to thank everyone for their time and their participation today. We just had a great turnout, so thank you.